Hello friends, welcome to Awdhesh Academy. Friends, in the recent years and particularly after the liberalization, we have seen tremendous growth of private sector undertakings. Today, most of the employment opportunities are available in the corporates. Most of the production and the service sector is in the domain of private sector. And therefore, it becomes very, very important that we should have some sort of legislation to regulate the private sectors. We have seen in recent years major scandals like Satyam, which has taken place in the corporate, which has actually caused tremendous loss to the investor and also the confidence of the investors in the investment regarding the corporates. So the government has brought certain changes in the corporate laws, and they have made some laws which would make the corporate more responsible and behave in more professional manner. So today we are going to start a new chapter that is about the corporate governance, and today we'll learn about the principles of corporate governance. Let us first understand the meaning of corporate governance. Corporate governance is the application of the best management practices, compliance of law in true letter and spirit, and adherence to ethical standards for effective management and distribution of wealth and discharge of social responsibility for sustainable development of all stakeholders. So what are the important terms here? The first thing is that we should use the best management practices. That the management is done in the best possible manner so that everybody has a trust on the corporate. Second is compliance of law. The corporate should follow all the laws in letter and spirit. It should also adhere to the ethical standards. Now the corporate should not behave like an immoral person or an unethical person, because corporate is also like a legal person or a legal entity. So it should follow the ethical standards which are applicable to other business entities, or for that matter the individual companies also. And we must ensure that there is a fair distribution of wealth. It should not happen that the people who are running the corporate sector or the people who are in charge of the corporate sector amass wealth at the cost of the investment or at the cost of the minor shareholders. They should also have a social responsibility, because the corporates make their profit from the society or from the members of the society. Their consumers are generally the members of the society, and therefore they also have a social responsibility for the sustainable development of all the stakeholders. Now, what is the purpose of corporate governance? The purpose of the corporate governance is conduct of the business in accordance with the shareholders' desire, that is maximization of the wealth, while conforming to the basic rules of the society embodied in the law and local customs. So even though the corporates are meant to create profit, but profit has to be created in the legal manner, in fair manner, and also in a responsible manner. And we should take care of all the stakeholders. We should build the relationship between various stakeholders in determining the direction and performance of the corporation. Now, corporation is not only for the shareholders. There are many other stakeholders in the corporates. For example, a typical company may have the following stakeholders: shareholders who invest their money, managers, board of directors, employees, customers, creditors, suppliers, and community. All these people have a stake in the company. If the company collapses, then everybody is affected, whether he is the customer, whether he is a supplier, whether he is an employee. So everybody is affected, and therefore the corporate has to behave in a responsible manner, because corporate has to fulfill the aspiration of so many stakeholders. The basic principles of corporate governance are as following. Number one, the sustainable development of all stakeholders. The second is effective management and distribution of wealth. So we have to see that the wealth is distributed in a fair and just manner to all the stakeholders and the shareholders. Discharge of social responsibility, application of best management practices, compliance of law in letter and spirit, and adherence to the ethical standards. So these are the principles which we can derive from the corporate governance. In order to achieve these principles or objectives, there are 4 pillars of corporate governance: accountability, fairness, transparency, and independence. Let us understand these 4 principles. First is the accountability. Accountability means that the corporate should ensure that the management is responsible to the board. All the people who are managing the company, they are responsible to the board, because board is the final decision making. Board is like a government. Ensure that the board is responsible to the shareholders. So these are the accountability principles. The second is the fairness. What is the meaning of fairness? Protect the shareholders' right. Nowadays, a corporate may be having hundreds or even thousands of shareholders. Everybody might have spent some of their savings in the corporate in the hope of profit. And so it should be ensured that all investors, all shareholders' interest is protected. You should treat all shareholders, including the minority shareholders, equitably. And you should provide effective redressal for the violation so that the confidence of the shareholders is there in the corporate. The next principle is transparency. What is the meaning of transparency? Transparency means ensure that timely and accurate disclosure on all material matters, including the financial situation, performance, ownership, and corporate governance. The shareholders have a right to know how the company is performing. And that is why nowadays it is common for the major corporates to declare their quarterly result, so that the shareholder is fully aware about the status of the company. They should know whether the company is making profit or they are making losses, what is their projection. So all these things are generally given in the quarterly statement or in the annual statement. And therefore, shareholders should know what is the exact status of the company. And finally, the 4th important pillar is independence. Independence means the corporate should not be able to judge itself, that it should not have a coterie where whatever they do, nobody can question, nobody knows. So there has to be some independent directors, there has to be some independent authorities who should be able to know how the corporate is progressing. So the independence is the 4th pillar, where the procedure and structures should be in place so as to minimize or avoid the conflict of interest. So the independence means there should be some procedures which should be in place, and there should be system which should minimize that the directors or the top management people don't usurp all the money which is there in the private company. Then independent directors and advisors, they are also appointed, and they ensure that the things are done in the fair manner, because they are not part of the company, but they have all the information about the company and they are the responsible citizen of the country. So friends, today we have learned about the basic principles of corporate governance, and then in order to ensure these basic principles, the government has made certain changes in the company's law that we shall do in the subsequent lectures. Thank you very much for watching the video lesson. Thank you. Friends, we have earlier learned about the importance of corporate governance. We have learned about the principles of corporate governance, and today we are going to learn about the specific provisions about the corporate governance in the Companies Act 2013. So first very important provision is the constitution of National Financial Reporting Authority. It has been provided in the Companies Law and the Companies Act is to constitute this National Financial Reporting Authority. The Union Cabinet on March 1, 2018 has approved the creation of NFRA for regulating the financial audit of the large companies. It shall have a chairman, 3 full-time members and 1 secretary. What is the job of an FRA? Its job is to formulate the accounting standards, monitor the compliance of the standards, and investigate the professional and other misconduct that chartered accountant and their firm commit. You must have seen that in the recent time, even the Prime Minister has once made an observation that the chartered accountants have failed to actually control or report the frauds which are taking place in the companies. And one of the main reasons for this is that the company themselves appoint the chartered accountant, and therefore the chartered accountants get paid for their work and they may not be so strict as far as finding the irregularities concerned. So that was the reason that National Financial Reporting Authority was constituted, so that they can investigate even the professional misconduct of the CS. The second important provision is about the audit and the auditor. It provides that the individual auditors has to be appointed for 5 years by every listed company. An auditor who has completed his or her term of 5 years will not be eligible for reappointment for 5 years from the completion of his term. An auditor shall have the right of access of all books of account and the voucher. This is a very important provision, because in the Satyam case also, it was claimed that all the documents, vouchers and everything was not provided to the auditor. So the auditor has the right to get all the documents, all the accounts, all the voucher, because based on that, they have to prepare their audit report and certify the company's authenticity. So auditor has to report fraud by officers or employees. An auditor cannot provide a banking or financial services to the company. So these auditors has to be exclusively doing the audit. They cannot provide any banking or financial services to the company, because then they will have vested interest in that. The third important provision is regarding the directors. It has been provided that at least 1/3 of the total number of directors has to be independent directors. 2/3 of the directors may be appointed on the basis of proportionate representation. The independent directors has been said to be the custodian and the conscience keeper of the board, because they will be outside the influence of the board. They will be independent. They will not be paid any regular remuneration, but they can receive a small remuneration and the reimbursement of the expenses. So when they do some work, for that only they will be reimbursed. They will not be getting any regular salary from the company. They may hold office up to 5 years, but can't hold office for more than 2 consecutive terms. So this has been specifically provided in the Companies Act. There is also provision of audit committee in the Companies Act. According to this, every listed company and the following class of companies shall constitute an audit committee. What are the classes? First is all public companies with a paid-up capital of rupees 10 crore or more, or all public companies having turnover of rupees 100 crore or more. So they have to constitute an audit committee. This is now mandatory required. The audit committee to have minimum of 3 independent directors. At least 2 of them should have understanding of the financial statement. It has been provided that the audit committee can investigate any matter and report the matter to the board. There has been very specific provision about the related party transaction in the company's law. First of all, we should know what is related party transaction. Related party transaction means the transaction at which the board member or their family members have direct interest. Suppose there is a company and it is having some directors. Now if suppose the company give some contract to one of the director or his family member as an individual capacity, then this will be treated as a related person transaction, because that can benefit the party who is getting the contract or the benefit. And therefore, there has been certain restrictions put on this, and it has been provided that if the transaction exceeds the specified limit, prior approval of the companies in the general body meeting is needed. So this provision has been brought to ensure that the company does not siphon off its funds to its near and dear, to its relative of the board or the board member themselves. There has also been a very specific provision in the company's law now about the class action. So let us understand what is class action. When you take a legal action, only the litigant get the benefit. Suppose a case is filed against the company by a person who is aggrieved of a particular type of problem, then only that person will get the benefit. But there may be many people who may be affected by the same type of problem. They will not get the benefit. Therefore, in the class action, all persons of the same class get the benefit. So that is a very important provision which has been incorporated in the corporate law. A class suit can be filed against the following authorities: a company or its director for any fraudulent, unlawful or wrongful act or omission. So it can be filed against a company or its director. The second is an auditor, including audit firm of a company, for any improper or misleading statement of a particular made in the audit report or for any unlawful or fraudulent conduct. And the third is an expert or an advisor or consultant for an incorrect or misleading statement made to the company. So in all these categories, a class action can be initiated. And the seventh important feature which has been incorporated in the company's law for the corporate governance is corporate social responsibility. I think many of you may be familiar with that. So let us understand what is the meaning of corporate social responsibility. This is a concept that suggests that it is the responsibility of the corporations operating within the society to contribute toward the economical, social and environmental development that create positive impact on society at large. Ultimately, a company is working in the society and it has the responsibility to the society, and they must ensure that some positive impact is made in the society because of their action. And in order to make this positive impact, some responsibilities has been fixed on the corporate. The inclusion of the CSR is an attempt by the government to engage the businesses with the national development agenda. So if the companies are earning profit, if they invest a small portion of that profit, which is just 2%, then a large amount of social good can be done. And this has been provided in the company's law. Corporate social responsibility is a very important provision, and we have made a separate lesson for this, and we will be presenting it in the next level. So today, friends, we have learned about the different provisions of corporate governance in the Companies Act 2013. We have learned what provision government has brought to ensure that the company run in a professional manner, the trust of the people is maintained in the company, and the company is not allowed to commit a fraud, or if they try to commit a fraud, that is detected as early as possible by having different provisions which has been incorporated in the Act. Thank you very much for watching the video. Friends, today we are going to learn about corporate social responsibility. This is a very important provision of Companies Act, and I have found that several times many questions in this paper of ethics, integrity and aptitude has been asked which expect you to know the knowledge of corporate social responsibility. This is very important provision because this is a challenge to the company to spend part of their money or part of their profit for the social welfare. This is a provision which has made the company do some of the social work and not only generate profit. Please learn this lesson very carefully, because you can expect some question from this lesson in the civil services examination. The first is on whom the corporate social responsibility provision or the CSR provisions are applicable. What is the scope of CSR? It is not applicable on every company, though every company can always do the social responsibility, but it is mandatory for certain classes, and the companies who constitute the corporate social responsibility committee, if they are having a net worth of more than 500 crores, or their turnover is more than 1000 crores, or their net profit is over 5 crores. So if the company falls in any of the category, then the CSR provision become applicable to it. Now, it requires that every such corporate which falls under the ambit of CSR will constitute a CSR committee or the corporate social responsibility committee. What is the responsibilities of this committee? We should know. The committee's responsibility is to formulate and recommend to the board a corporate social responsibility policy, which shall indicate the activities to be undertaken by the company as specified in the Schedule 7 that we shall learn later. Schedule 7 specifies certain type of activities which can be undertaken by the corporate under this Act. It shall recommend the amount of expenditure to be incurred on these activities, and it should monitor the CSR policy of the company from time to time. So every corporate has to make this CSR committee, and these will be the responsibilities of the CSR committee. Now, CSR committee will be acting through the board. And what are the responsibilities of the board? Let us learn them now. The board will approve the corporate social responsibility policy of the company and disclose the content of such policy in its report and also place it on the company's website. So it's made mandatory that the policy of CSR should be placed on the website. It should ensure that these activities are undertaken by the company, because board is having the ultimate power of governance, and therefore it is the responsibility of the board to see that CSR policies actually implemented. The company spend in every financial year at least 2% of the average net profit of the company made during the three immediately preceding financial years. So the company is responsible for spending at least 2% of the profit, and the board has to ensure that the company spend minimum 2% of the profit. It should give preference to the local area and the areas around it where it operates. So the company should try to first see if they can spend that money in the area which is around them, so that the people who are affected by the company or who are close to the company are getting the benefit. If the company failed to spend such amount, the board shall specify the reasons for not spending that amount. So that is the responsibility of the board. Now let us learn about the different type of activities which can be undertaken by the CSR. One is the eradicating extreme hunger and poverty, promotion of education. Education is very, very important for India, and we are lagging behind in education. Government is spending from the exchequer some amount of money or a good amount of money for education, but the corporate can contribute a lot because they also have a professional approach, and so promotion of education is also one of the very important activities. Then promoting the gender equality. This is also very, very important criteria in our country. The woman has to be more empowered, and so they can spend on this area also. Reducing the child mortality. In India, we still have a high rate of child mortality, and so the corporate can contribute in this area also. They should also spend in ensuring the environmental sustainability, because environmental degradation is also one of the major problems now in India, because we are growing at very fast pace, the fastest in the world, and therefore the corporate can ensure that there is no environmental degradation, or they can contribute in this area also. They can also spend for enhancing of the vocational skill, because that can provide employment to the young generation. They should spend in social business projects that can improve the society. They can also spend on the measures for the benefit of armed forces, veterans, war widows, and their dependents. Another area which is provided for the corporate social responsibility clause is training to promote rural sports, nationally recognized sports, Paralympic sports, and Olympic sports. So in order to promote these things, they can also spend their money. Then government has also included funding to technology incubators located within academic institutions approved by the central government. You may be aware that the central government has approved many institutions like IITs, IIMs, where there are incubation cells who will be promoting entrepreneurship and the startups. So these companies can spend there also. They can contribute to the PM's National Relief Fund. They can also contribute to rural development projects, or they can contribute to the slum area development. So we have seen that a large area has been specified where the companies can spend their corporate social responsibility fund of 2% or more. So we are expecting that if the company really spend this in the fruitful manner, then the growth of the country can be expedited, because the professionalism of the company coupled with their social responsibility will drive the economy of the country. Thank you very much for watching the video. Thank you very much. Friends, we have earlier learned about Companies Act and the CSR provisions. There has been some updates till now, and we are going to learn about those updates today. So friends, first of all, we should know that before these updates were made or before these amendments were made in the Companies Act, what were the provisions about the CSR violations and the other violations which were done under the Companies Act. There was no specific provisions for CSR violations. There were general provisions only, and general penalty were to be levied for flouting the rules and norms which are provided in the Companies Act, and if you are repeating those offences, in that situation a more severe penalty was to be provided. So the first important section is section 450, under which a fine up to rupees 10,000 could be levied. But if the contravention continues, then up to rupees 1,000 for every day thereafter, the penalty should be added up. So that was the provision under section 450. There was another provision under section 451, that if the same offence is committed for second or subsequent occasions within a period of 3 years, then the punishment should have been double in addition to whatever imprisonment what was to be provided. So these were very lenient provisions, as a result of which what happened, that many of the companies were not spending the money which they were required to spend under the CSR provisions. So the government has brought some tough provisions. We'll learn about that shortly. Another very important development which you should be aware of, that the government, as you are aware that in light of this COVID-19 pandemic, has created one PM Cares Fund. And this PM Cares Fund, we should know how it is connected with CSR. So to meet the emergency or distress situation like what is posed by COVID-19 pandemic, a public charitable trust under the name of Prime Minister's Citizen Assistance and Relief in Emergency Situation Fund, that is PM Cares Fund, has been set up very recently. And the donations which will be made to the PM Cares Fund will qualify to be counted as corporate social responsibility, that is CSR expenditure under the Companies Act 2013. So this is a new development. You should be aware that if the companies, instead of spending on any other thing, if they rather decide to donate on the PM Cares Fund, then that will be qualifying the expenditure under the CSR provisions. Now let us know about the Companies Amendment Bill 2019. The Companies Amendment Bill 2019 was passed by the Parliament in July 2019. And this particular bill ensures accountability and better enforcement to strengthen the corporate governance norm. So the main focus of this particular bill was to ensure that people actually spend the money if they are supposed to spend under the CSR fund. So let's see what are the amendments which has been done, particularly in respect of the corporate social responsibility. Now earlier, if the companies which were to provide for CSR, they do not fully spend the funds, they must disclose the reasons for non-spending in their annual report. So if they just disclose why they have not been able to spend, that was sufficient. Now after the amendment, any unspent annual CSR fund must be transferred to one of the funds under section 7 of the Act, for example PM Relief Fund or now PM Care Fund also, within 6 months of the financial year. However, if the CSR funds are committed to certain ongoing projects, then the unspent funds will have to be transferred to the unspent CSR account within 30 days of the end of the financial year and spent within 3 years. So this provision is that if you are not able to spend anything, then you have to transfer it into another fund, that is unspent CSR account. That means you cannot use that money for any other purpose. And any fund which remains unspent after 3 years will have to be transferred to one of the funds under Schedule 7 of the Act, for example, PM relief funds. Now the most important amendment which has been done is that there has been severe penalty for the violation of CSR provision. Earlier, no specific penalty was provided under CSR. We have discussed that only general penalties were there, which was quite lenient. Now, after the amendment, any violation will attract a fine which can be from rupees 50,000 to rupees 25 lakhs, and every defaulting officer may be punished with an imprisonment which can be up to 3 years or fine from 50,000 to 25 lakhs or both. So you can understand that this provision has become very, very stringent. If you fail to spend the money under CSR, then a huge penalty as well as jail term can be given to you. This naturally created uproar in the corporate community because CSR was supposed to be a voluntary type of activity for the social benefit, and make it a criminal offense was resented by the trader industry. I will shortly update you about what is the latest provision in that. But before that, we'll pick up another provision which has been made in the amendment, that is debarring the auditor. Now earlier, the National Financial Reporting Authority debar a member or firm from practicing as a chartered accountant for a period between 6 months to 10 years for proven misconduct. That was the provision earlier. Now, according to the bill now, this amends the punishment to provide the debarment from appointment as an auditor or internal auditor of a company or performing a company's valuation for a period between 6 months to 10 years. That means now that person cannot act even as an internal auditor of a company or perform the company's valuation. So the scope has been widened now. Now let's get the latest updates on the amendment. In March 2020, the government approved 72 amendments to the Companies Act when the bill was passed, and it removed the imprisonment angle and reduced the punishment which is proposed under the Companies Act. It exempted companies which have an obligation to spend 50 lakhs or less from the requirement of having a corporate social responsibility committee. Another very important provision which has been brought is that if a company has spent more than 2% of the net profit in 1 year, the general approach was to count only 2% under this obligation. Now the excess amount spent to be carried over to be adjusted against the obligation in the subsequent year. Now suppose you have to spend 2% and you have spent say 5%. Now earlier provision was that it will be treated only for that particular year, that is only 2%. But now suppose you have spent 5%, then whatever excess amount you have spent, you can adjust in the subsequent year. Now it further allows companies with inadequate profit to offer remuneration to the independent director the way the executive directors are rewarded. So in certain situation, the independent director can also be paid some remuneration, but that is not for the companies which are making huge profits, but only if they are not making enough profit. In that situation, in order to attract the the directors, independent directors, this provision has been made. As we have discussed that, there has been quite an uproar about the penal provision which has been incorporated under the CSR, particularly the jail term. So in order to look at that, a high-powered committee was set up. So the government has set up a high-powered committee which is headed by Corporate Affairs Secretary Ing T. Srinivas to look into the grievances of the corporate. And the government promised that it shall not operationalize the new corporate social responsibility provisions in the recently amendment Companies Act that made violation punishable by jail. And so the government assured that it will not issue the follow-up rules to implement the provisions. That basically means that the provisions, though it is there in the law, it will not be implemented. Now, the high-powered committee has given certain recommendations in respect of the CSR, which are as following. The CSR violation should be regarded as a civil offense that are liable to monetary penalties. That means no jail term. Only the civil offense, that means only penalty should be levied. CSR spending should be eligible for tax deductions, and companies be allowed to carry forward unspent balances for 3 to 5 years. That means we should provide tax exemption or tax deduction on the amount which is spent on CSR. CSR should not be regarded as a means to resource gap funding for the government scheme. So we should try to see that CSR remain a voluntary thing and people come forward themselves and spend the money, rather than we should create a fear in the mind and try to get the resources of the company for the development expenditure. The CSR spending should be made a broad driven process and provide innovative technology based solutions for social problems. So we should not restrict the CSR to certain limited activities. We should rather broaden the limits of that activity. The next recommendation is that the CSR activity should be aligned with sustainable development goals. It further recommended that the CSR activities must include sports promotion, senior citizens welfare, welfare of the differently abled persons, disaster management and heritage protection. That means certain new activities must be added into the CSR spending, because these are also things of national priority. And so these are the recommendations which the high powered committee has made on CSR. So friends, we have today learned about the recent changes which has been made under the Companies Act and the CSR provisions, and it is to update your knowledge. Thank you very much. Friends, in recent times, the corporate social responsibility or CSR has been linked with trusteeship, and the concept of trusteeship was given by Mahatma Gandhi. So nowadays we are trying to link the CSR responsibilities of the organization with the concept of the trusteeship. So this has become one of the very important topic in the modern time, and today we are going to learn about this particular topic. Now, how this is started? The idea that the corporate should fulfill their social responsibility and the concept of trusteeship, which was given by Mahatma Gandhi, has a lot of similarities. And this has been brought forth in the recent developments when in October 2019, the President of India presented the first National Corporate Social Responsibility, that is CSR award, to the selected companies. While presenting the CSR award, the President observed that the contribution through CSR is a true manifestation of the trusteeship philosophy of Mahatma Gandhi. Because Mahatma Gandhi has given the concept of trusteeship, but it was never actually implemented. So, according to the President, this concept of CSR is very close to trusteeship concept. And accordingly, the President announced that the National CSR Award will be given away on 2nd of October every year in the memory of Mahatma Gandhi. So, in a way, this CSR has been formally linked with the concept of trusteeship. Let us now understand what was the view of Gandhiji in respect of the trusteeship. Gandhiji, as we know, has given the idea of trusteeship, and which has provided an alternative to capitalism and communism. We know in the capitalism, everything is decided on the basis of demand and supply, while on the communism, the entire property is basically vested with the government. So it's a government-owned businesses and government-owned decisions. Now Gandhiji favored neither of them. He was not in the support of pure capitalism, and he was also not in the support of forceful acquisition of wealth as it was done in the communist countries. His idea of trusteeship was as following. He said, supposing I have come by a fair amount of wealth, either by way of legacy or by means of trade and industry, I must know that all wealth does not belong to me. What belongs to me is the right to an honorable livelihood by millions of others. The rest of my wealth belongs to the community and must be used for the welfare of the community. He further added that the rich man will be left in possession of wealth of which he will use when he necessarily requires and reasonably satisfied his personal needs, and then act as a trustee for the remainder or to be used for the society and by the society. So what Gandhiji basically told, that you do the business, you make money, but remember that more than what you require, the rest belong to the society. So it should not happen that we should spend all the money for our own benefit, but rather after taking out our own share or taking a reasonable, comfortable life, whatever rest is there, we should give it to the society. That was the concept of trusteeship of Gandhiji, and he believed that we should consider ourselves as the trustee of the wealth rather than the owner of the wealth, and therefore we should try to make best use of the wealth so that it provides maximum benefit to the society. Now let us try to understand how Gandhiji developed the concept of trusteeship. For this, we should know the philosophy of aparigraha, which is a part of Jainism and also part of Hinduism. Now, the idea of trusteeship is basically based on the Indian values of aparigraha, that is non-acquisition of excess wealth or property. So, both in the Hindu religion and also in the Jainism, it is not advisable to acquire lots of property and wealth. So, acquire wealth, but whatever is necessary, more than that is not required to be acquired. We can use our wealth either for self-satisfaction or for satisfying the needs of others. But when we are doing business, we may acquire lots of wealth. Now that wealth either we can use exclusively on ourselves or we can use it for the benefit of other people. Now if this concept of aparigraha is to be imbibed, the issues like what to produce and how much to produce would be tackled from a different perspective. Let's try to understand that. When we are trying to maximize the wealth for ourselves, we will try to produce those goods where we have maximum profit. While if the society's need is our priority, then we will try to produce those goods which society needs the most. We may not get maximum profit on that, but our priority is society, and therefore our production will be based on the need of the society, and that is how the concept of aparigraha basically helps. Now let us try to understand the characteristics of trusteeship. There are 4 characteristics of trusteeship. The first is that trusteeship is based on ahimsa. So the use of force is totally prohibited as it is normally done in the communist country. So it is provided that the rich people to volunteer as trustee because it will provide them the greatest happiness by parting with the wealth. When we are sharing our wealth with other people, we are making other people happy, and that actually gives us happiness back. And therefore, the rich people will be motivated to share their wealth. The second concept is trusteeship allows creation of wealth. So trusteeship does not prohibit you to create wealth. It allows creation and possession of wealth. However, don't possess all the wealth, don't exploit workers and make workers partner in business. So you are allowed to create the wealth, but not by exploitation of the worker. Try to give them fair wages so that they also grow along with you. The third important thing is trusteeship and nature. According to this concept, the trusteeship seeks sustainable development. Production of goods and services should be based on the demand of the society, and the cost to the environment must be included. It means use carbon trading to protect the environment and use appropriate technology to minimize pollution during the production process. So as we can very clearly see that when we are talking about the trusteeship, we are taking the responsibility of the environment also and of the society. So we are not going to produce something which is going to maximize us the profit. We should rather see what is going to be its implication on the society. So if something gives us a lot of profit but not good for the society, we will not do it. But something which basically is useful for the society may not give us much profit, we will go for it. In the same way, we will use all the technologies which will reduce the pollution and the damaging environment in fact. Another very important thing is trusteeship in consumption. Now, an aparigrahi basically reduces his personal consumption to the minimum. Once our needs are satisfied, we must spend the rest of wealth for the social good. While an ordinary person or a greedy person or a materialistic person try to spend maximum money on him and his family, but a trustee will keep his requirement to the minimum and try to spend as much wealth as possible for the society. And that is how trusteeship will create a better society. People will have trust over the wealthy people also, and there will be better bonding between the poor and the rich, businessman and the ordinary person. So now let's understand the concept of CSR as trusteeship. So this trusteeship concept impacts the society in a very positive manner, because otherwise the poor people see the rich people as an exploiter, but when the concept of trusteeship is used by the rich people, then they will see them as better human beings and there will be much better bonding. People will minimize their needs, which will help fair distribution of goods to all citizens of the society, and it will create an equitable world. Now, what does it mean? When people today have wealth, they try to live lavishly, get most expensive cars, live in big houses, while millions of people don't have a room to live. So when you are following this concept of trusteeship, then what you are doing is that you are going to keep your requirement minimum so that maximum wealth is available for the benefit of the society. The CSR seeks to realize the vision of Mahatma Gandhi by giving all the industries an opportunity to serve the nation by parting a small fraction of their profit for improving the society and fulfill their social responsibility as a responsible being. And therefore, this CSR is an opportunity where you can spend at least 2% of your profit and you can create a better society. And that way you can fulfill your obligation as a trustee of the wealth. So friends, the concept of CSR and the trusteeship is very much linked, and we should know this, as this is a very, very important thing for us to know in the Indian context. Thank you very much.